Central University of Kerala. I welcome you all to this group discussion. We have for the meeting, we have Dr. Dilshad from, she's the Dean, School of Law from Satyabama University. Then we have Dr. S. Manohar Nayak from the Central University of Kerala. We have Professor Alagu Manikavail also. Scholars from the field of law, uh, engineering and technology are present with us for this discussion. This discussion is just a preliminary round for wider consultation. If the participants today suggest that we should, at the end of the discussion, if they feel that we should have a wider consultation or wider discussion, we will organize a program in the month of April physically, to be present physically, and the purpose of this discussion is today, as you all of you know, we are living in a digital world. Not the real world, but a virtual world where 99% of our needs and services are routed through the digital world. Except the food on the table, which is real, even healthcare has come online these days. So, except the food we eat, everything is now within the digital world. And the conduct within this digital world is to be regulated. Like we are already, our society, we have laws to regulate our conduct. But however, in the digital world, we do not have a comprehensive law to regulate our behavior, conduct in the digital world. So that is why we thought the institute, when we discussed after our program on 26th November, uh, we had a Law Day celebration last year, and after that, when we met, we decided to find out how best we can contribute in data protection, in protecting our personal data in the digital world, which is a burning issue these days. And it is also the most important need in the present day. So, with that in mind, we had called for this group discussion, and you all know that the Personal Data Protection Bill 2022 is pending. The earlier version 2021 was withdrawn. It was not introduced in the parliamentary session. It was withdrawn, and they promised, the uh, government promised that it would introduce a comprehensive data protection, personal data protection bill uh, in 22. So they are in the process of introducing a comprehensive data protection policy act. The bill is, it is in the form of a bill today. It is yet to be introduced in the parliament. As on date, but as on date, uh, what we have uh, is only in the form of policies, interim guidelines, and piecemeal uh, administrative instructions under the Information Technology Act and rules. So that is why we felt that this is a very important area which will or which is affecting our life, not only our official life but also our personal life. So with this thought in mind, this meeting was called, and since this is a subject which involves both law as well as technology, we thought it fit to invite people with uh, people who are eminent enough to contribute to the technical aspect of the subject. So that is how we have Dr. S. Manohar Nayak and Dr. Alagu Manikavel here with us, uh, covering the technical side of the or the technology side of it. Uh, it's very important we know the technology aspect of it also, because normally uh, our disadvantage or our complaint is that the law is not in par with the technological advancements in society. Any uh, any aspect of law, whether it is consumer protection law or cyber crime, any aspect of law, we always have this complaint that the law is not keeping abreast or at least in par with the technological developments. So that is why we should also have some knowledge while we are discussing the legal aspects on data protection. We should have some knowledge of the present state of technological development, because after all we cannot protect our data without knowing uh, how our data is being used or how our data personal information is being stolen. I also had some very personal experience on this subject. uh, Once I went to get a mobile phone connection other than the one which I'm having now. Somebody suggested you should get a second one. So I went to the Airtel company. Their agent is here in town. So I went there to get a Airtel phone connection. So I just told my name, and they asked for my ID. So at that time I had my Aadhaar card, so I gave the Aadhaar card. He immediately, that person, took all my information, like my address, age, my profession, uh, including my driving license number, etc. And she gave me, sir, you sign this form, and she gave me the connection. So I asked her, how did you get all this information? She said, we got it from the Aadhaar. We downloaded all your information based on your Aadhaar card. I was actually very surprised, and I was wondering when I was returning back home, I was wondering how safe is our information. And this happened some time back, not in the recent past. It happened a few years ago. So that is the situation in which we are today, and still we are not in a position to protect our data. Uh, I came across an interesting piece of information. It is possible to predict your purchases in a supermarket. That is what I heard, I read somewhere in one uh, paper. It is possible to find out what products you will need. So there was one company, online store, uh, and this online store was targeting uh, pregnant women based on their previous purchases. Whatever they used to purchase in a departmental store, based on the products they were purchasing, they were able to identify the customer, whether the customer was pregnant or not, and they gave advertisements. They tailor made advertisements to that customer to uh, tailor made one, two, three. Tailor made advertisements to provide products for her because they came to know from her previous purchases that she was pregnant. So they have the online store, the departmental store was not only predicting her behavior but was also influencing her behavior to buying products of their store. So this is also an alarming situation, and like this, most of our members felt that this topic is of so seminal importance that we need to contribute to the development of law. So the legal aspect being one part of it, we have the technical side also, and how will we protect our information if we do not know if our information is being uh, accessed or stolen by others uh, without our knowledge, or with our knowledge but without any means to stop it. So that is why uh, Dr. Manohar Nayak is here with us, and he was kind enough to uh, consent, to give his consent for his participation to enlighten us on the technical side. So now I would invite and request Dr. Manohar Nayak to enlighten us about the present status or state of technology used for collecting our personal data in the digital world, and whether there are technologies to protect our personal data. So, with this input, we can then switch over to the legal aspect, and we can discuss the legal aspect in a better informed way, because without knowing the technicalities, we will not be in a position to contribute in a better way. So, I please, Dr. Manohar Nayak, please give us your input, and we would be
We would be
kind enough to
kind
hear you.
enough to hear you. Uh, yes, sir. Good morning, sir. Respected Vincent sir and other dignitaries, and this group discussion on data protection bill. Uh, very good morning, and I am very happy to be with you through this online mode to discuss uh, on some of the concepts regarding the data protection. So, as our Vincent sir already mentioned, so what is the importance of the data protection? Because now we are in the world of the digitalization, and day by day we are completely depending on online transactions, doing online transactions through our digital devices. So these digital devices, so earlier how we were doing, even for example, if we want to open our email also, We may be using our personal computer, but nowadays we are also increasing the usage of. So the increasing the usage of the devices have also been increased. So, and nowadays, whenever we are going to a market, supermarket, or even small shop, even visiting a canteen, in that place also, what we are doing, so we are just doing the transaction and paying the bill through online. So, like that, everywhere, in every aspect in our daily life, we are completely depending on lots of digitalization. So that's why our sir mentioned, Vincent sir mentioned, we are in the digital world. And through the digitalization, we are getting lots of benefits. And as Or mentioned, I will speak and I will talk about only technical aspects, but I am not good at these cyber laws and all those things. But in technical terms, the importance of the technical terms,
Like my
technology, I will discuss about the data protection. And actually, here earlier, in early days how we were using the networked system. So through this network we are getting lots of benefits. So earlier we were having only individual systems. Through the individual systems we were doing some small works. And when this interconnecting aspect came, this technology aspect came, so through this interconnection, we are doing lots of things. This made lots of benefits like resource sharing and increasing the throughput and saving money. And sometimes the major benefit of this networking system is communication facility. So earlier, to do a small communication, we were using
access.
postal system, postal department, or depending on postal services. And if you are posting a letter that in that specific location, if the recipient is not there, he can't read that information. But through this digitalization, the whole world has become a global village. And through this global village, wherever the person may be, he can access that information instantly. If I am sending an email to a particular person, he can access that information wherever he may be. Through that place, he can access the information instantly. That benefit we have got. And resource sharing is possible. Lots of benefits are there. And through this internet, earlier if we see almost 19 in between of 1960 to 1970s, that the interconnected devices throughout the world, if we want to count how many interconnected devices are there globally, then we can say only some 100 to 1000 numbers, that's all. So the first networking system was developed by that US military system, that is nothing but a ARPANET, through which some all these the applications of the networking system like resource sharing and then computation throughput, increasing the computation throughput and saving money and distance, time in terms of we can save the time, and in terms of communication facilities, these are the benefits. But for these things, for the US military system developed this ARPANET, through which only some thousands of systems were there globally. But now this interconnected, actually the term interconnected means if the two systems are able to exchange the information, then it is called as a interconnecting. So interconnecting system means here both systems can able to access the resources. They can share the information. So that is the meaning. So here through this interconnectivity, so that actually this internet term we know that here all the experts they may be knowing this internet means the interconnected networks. So actually the two systems means only two individual systems. Interconnected means they are able to exchange the information, then it will be interconnected. So this network, so the group of networks have been interconnected now. So then through these lots of benefits are there. And if we see the current time at this particular moment, at this current instance, how many interconnected devices are there throughout the global? Even now, at this moment, if we want to see some millions and trillions of computer systems, that was the current situation of the dependency. It shows the current dependency on the internet or current dependency on the digitalization it will represent. That's why here that type of more usage is there nowadays in everything. Even we are doing lots of even we are not doing any business transactions, visiting a particular showroom or a particular market physically, sitting at our home, and whatever the desired product that we are purchasing through some e-commerce business sites, and we are doing the transactions, and automatically that product will be delivered to us. Like that we are doing the several things. Even we are not visiting to the bank, and whatever balance and whatever the transactions, if we want to transfer some amount to other persons, or all these banking transactions through online banking system, net banking facility we are doing. Like that, so many things we are nowadays we are doing. And now the latest thing, the technology is being increased, and this internet is becoming like a pervasiveness. So wherever, everywhere, the application of the internet we can see, that is nothing but the Internet of Things, IoT. Even this is a very important application with which lots of benefits are there. Even without human intervention, we can connect our home appliances, and we can interact with them. For example, our smart home, the smart home, if it has been expected, if it has been interconnected with lots of home appliances, smart appliances, and if there is a backbone, or the key concept behind the smartphone is a internet. So through the internet, we can connect all the home appliances devices, and we can we can ask the device to perform certain tasks. For example, if Amazon is providing a particular voice recognition device, that is Alexa, we know that through Alexa, if all the devices have been interconnected through the internet, and we can speak with a particular device, and for example, Alexa, switch on the television, and go to that channel number, and Alexa, make me wake up tomorrow morning 5 a.m. Like that. Alexa, play a particular song, like that. Then that corresponding device will be automatically response. And if I want to tell that switch on that bulb in that specific color, glow that bulb in a specific color. So if we are telling like that, all the things will be performed through our voice that has been connected through that Alexa voice recognition system. That through that system, that every device can be operated. So like that, lots of benefit. These are the few things I am telling, because all of us we know all these types of technology through the Internet of things. Even many activities and many applications are there. Even wireless sensor network, we can do lots of without human intervention, we can monitor, and even precision agriculture we can do, and all the benefits is through the digitalization we are enjoying. So how the dependency of the digitalization is being increased, at the simultaneously the threats, as Vincent sir told, when sir is going to purchase, given a right example, during the time when sir was going to purchase a particular Airtel SIM card, due to that time, everything, all the details that a network service provider collected and telling. Then sir was surprised. This is not happened during recent time, but 2 years back almost. So, like a situation of things, we are encountering certain threats without our knowledge also. Sometimes we may be surprising. Even many of our students or many of our friends telling that if we are visiting a e-commerce site or somewhere else and searching for a particular product to purchase, then our interest automatically will be analyzed by that site, and then onwards we will receive so many phone calls, or some even you may be accessing some browsing something from your internet, and those ads, these will be this device or this product from so and so, you may get offer. Like that, lots of things, we may get certain ads also while browsing the internet. So like that, lots of things, how the people, how our personal information will be stolen, how the others are knowing our personal information. So here, that is a very important thing. Here, the problem of now here we can't say the problem of the internet, because lots of advantages are there through the digitalization. But I'm telling that this is like a building a beautiful house, and no fence, no compound wall is there, then automatically danger. Similarly, here also, we can't avoid the digitalization because of the threats, because of the unsafetiness of the data protection. We can't avoid, but we should take certain precautions. So we should definitely go for some advanced security strategies we need to follow. So through which only even the security in terms of even whatever security, even physical security also. There may be a university without a compound wall or without a particular security system, physical security. If any other unauthorized person is entering into that organization, that leads lots of complications. So the unauthorized person entry should be restricted. So that's why certain security services we need to implement to our organization, so with which we can protect our system. So in actually the current nowadays, whatever the threats, even lots of security mechanisms were being implemented by the security experts. Even though hackers or the cyber criminals automatically changing their techniques to steal our confidential information, and immediately they are modifying their techniques or designing new techniques to steal or to damage our system. And even we are depending some, for example, these are the days like that. Earlier we were expecting like some cyber war. Actually nowadays, if we are because if we see individually, if we are losing our personal information, that may not be that much of impact. If we see a organization, example, a particular banking system, that server has been damaged because of a certain cyber threat. So that server, banking server, is having all the important information of the banking customers and their balances and all the information. Suddenly that system is making that system unavailable or interrupting that system. Due to that, lots of consequences may happen, and the loss is very irrecoverable. In such a way the situation may take place. So to that's why here, if we see at a particular every hour how many, or every minute or every second, some, if we refer certain statistics, I am not going to deeper all those statistical information. Even per minute how many cyber threats are happening during the world, and throughout the world. And if per hour or per year, lots of threats are there. Even among those threats, certain common threats like nowadays the phishing threat is becoming more popular. And this apart from various threats like distributed denial of service attack or threat or phishing attack, or if we see SQL scripting attack, or that session hijacking attack, or ransomware attacks, like that, lots of things, even man in the middle attack, network sniffings, like that, password spoofing, and lots of things are there. Even your password, how that will be stolen. Yeah, even for example, I may be sending you a particular attachment. This is the syllabus, or this is the invitation, this is my photograph through an email. So that email, if we are downloading that email automatically, so for example, that how hacker is trying to steal your personal information. So in that attachment, he is very intelligently attacking, including or embedding a particular malicious software. That malicious software may be, for example, a keylogger software. That keylogger software he embeds, and that before embedding that keylogger software, that is a malware, malicious. That malware is nothing but malicious software. He is including how actually that hacker or a intruder or a cyber criminal enter into your personal system. Means not, he can't directly physically enters, but through various malware. In our example, the he, through malicious software, he is injecting into that attachment, and before embedding that attachment of that malicious software, and after embedding, the size of that file may be similar, same, and he may be just attaching to that email and sending to a particular victim person. So that victim person, by seeing this mail, he will feel that this is a very important mail, and by clicking that, so automatically whenever that document is being opened, it will be installed automatically in your system without the knowledge of the user. And then whatever that keylogger it will do, it will records all the keystrokes, whatever he is entering that username and password and all those things, and automatically those will be stolen and recorded in a particular log file, and even screenshots, and all these things automatically from his account to the hacker account. A corresponding that keylogger software will send a mail every 15 minutes, or every 10 minutes, like that certain email will be transferred from victim system to attacker system. So the attacker knows whatever the victim is doing on his system. So what sites he is going to open, and what he is doing, what keystrokes he has typed. Based on that, those he will steal all our personal information. So like that, certain things are happening. So even phishing attacks, lots of even some person will clone our. Even for example, I want to do a particular transaction. For example, I want to purchase something, or even I want to open a Facebook account. Then what this, just we may be searching Google in googlefacebook.com. So then certain Google will display lots of pages. So any page you may be clicking without a particular awareness, and immediately what happens? So the exact similar page of the cloned Facebook page may appear sometimes, and we may feel that this is a original site, and their username and password we need to enter, and login name and password if you are entering that cloned website automatically captures your username and password. It will be transferred to the attacker, and then immediately that cloned web page redirects to the original page, and again we need to enter. It will ask to enter that username and password. Then we may be thinking that something happened. I might have not entered that username password rightly. That's why it is asking the next time. Like that we may feel, and we may re-enter and reconnect into that page. But before that, automatically uh, so automatically that attacker will steal all our information. Such a way the threats are being happen, and even the hacker may clone any banking site or any other things with various tools. And even in our research scholars here, Ashida is also there, and in our department, another research scholar, due to his busy work, and he not attended to this discussion. He Both of our scholars are experts in technical, in terms of technical aspects of these cyber threat attack demonstrations. We are giving lots of demos to our students. So how even my research scholar, Ms. Hashida Hydros, she knows lots of that she is expert and doing her research from past 3 years in the area of Android malware threat detection. And so there also how that Android malwares, even it closely similar. For example, that earlier we were using our Indian government banned lots of apps. So whenever you are installing certain apps into your mobile, so automatically it will ask certain permissions. If you are not giving the permission, so it won't be installed. So even though that app may not require certain permissions, we need to give. So such a way the developer of that app will create that information very easily, and that will be shared, and that will be kept in a Google Play Store. And if we wanted to install that one, while installing, it will ask certain permissions. Even certain permissions will ask to make a call, or to make our storage device modification permissions. All these permissions, read and write, SMS permissions, it will ask. If we are not giving the permission, if we are not giving the permission to access those things, that app may not be installed, and the user of that app may not be aware of the consequences, and he will give the permissions, and immediately it will be installed, and lots of our personal or important information will be stolen. So that's why here lots of things are happening that's why that the government, Indian government, recently banned lots of mobile apps, especially developed by the Chinese, and they have been restricted and banned by us also, because even these apps, how data protection may be lost, and how the data protection will be compromised through various other apps. Those demonstrations also we are giving generally in our classes, and like that, many things are happening. But here, because of the threats, we can't avoid that usage of the technology. And but we need to develop we need to enhance the security mechanisms. And as I told you, even we are the security experts are day by day, they are doing some lots of patching mechanism for every software, but still that attacker also simultaneously he is increasing, he is intelligently modifying his technique. So like that it is going on, but it is a continuous process. We can't avoid the technology, and we need to use lots of security enhancement techniques. So lots of things are there, but here this is a group discussion. I can't take more time, and whenever any doubts or any during the discussion, I can communicate during that time. And with these few words, I will conclude. And thank you very much for giving me this opportunity. Thank you very much, sir. Thank you.
Thank you, Dr.
Thank you, Dr.
Manohar Naik. I'm
Manohar
very
Naik. I'm very
glad that you are able to enlighten us on a few things like the importance of a compound wall around our personal data, and how over a period of time things have evolved, and today our lives are saturated with the digital world. So thank you very much for these highlights. Uh, Now we have other participants also.
participants also.
I will now
I
call
will
upon
now.
Professor Alagu Manikuvel to introduce himself and say a few words.
Thank you, sir. Yeah, myself, Monica Velu from the Central University of Kerala. So first of all, I would like to thank Dr. Cyril for this opportunity. You know, we casually
We
had the
can.
discussion, and then we came up with this plan of we have the experts. So that's how I have requested the Department of Computer Science, and then Dr. Manohar Naik immediately accepted to be part of this program. So I take this opportunity to thank Dr. Manohar as well. So yes,
So yes,
and then we have the
and then
research
we have the
scholars as
research
well, both from the computer science as well as the genomic science as well. Quite interesting. I think this is a new dimension of discussion. We always discuss in the same subject, either or somehow related subject like computer science and biological science. We used to talk for the bioinformatics. I think first time we moved out of this big change towards the law. Maybe the next time we do have the law department, but it's not in our campus, in some satellite campus. Next time, hopefully, we would like to bring them also. Hopefully, it will be our more interested discussion. Coming to my point of discussion, so basically, I'm a biologist, so kind of out of scope from this discussion. But I thought when Dr. Cyril as well as Dr. Manohar has set the platform, I realized that maybe I could also add from the genome side, because data is data, whether it is a digital data or the data come from the physical things or come from the biological things. Data is data, and all are developing the data. We are in the era of, we use the word big data. Huge data are there, so who is using and how we are going to use it, and then whether we do really have the ethical point of view in all these things is a matter of concern. Especially coming to my area, we have been developing a lot of biological data from the human, from the plant. Anyway, plant case, let's keep it aside. Nobody's going to raise the question on plant, but at least, you know, in the case of human case, a lot of data we are generating from the lab. So how really it's going to be handled carefully is the point of my discussion. For example, until now, you know, whenever we get some health issue, we are simply going to the doctor. The doctor is prescribe him some medicine, and then we are just moving on. So slowly the situation going into the different era. It's called personalized medicine. In that case, individual basis year after the medical care going to happen. So in which basis? Basically, they are what the biologists or the genomic people going to do is we are going to generate the data from the individual human being and then going to prescribe the medicine. That's what the simplified way of personalized medicine. If that is the case, how much my data, my own data about me, for example, Manix, so how much Manix data is going to be stored in a proper way? Who is taking the responsibility? Whether the patient myself has to take the responsibility or the doctor to whom I'm handing over my data to have a look and then give the medicine is the person going to take care, and next is the database, because usually whenever we generate the data we submit in the database, so it is public. If that is the case, how really the world is going to handle this one? So just for the discussion, I'm putting this query here for the next discussion. So thank you very much, sir. I'm handing over the things to you.
Thank you, Professor Manikavel. Actually, it's quite interesting that you opened up one important area, that our own personal information from our body is going to be used for treatment, which means our very core details, information about us will be in the digital world, and it highlights, this point actually highlights how it is important to protect it, because if you look at the digital personal data protection bill, to put it mildly, I am
Some audio issue is there, na sir?
Yes, some network issue it seems.
Okay, okay, sir. Okay.
effectively protected. So, thank you for highlighting this point. We'll have to keep this uh, point in mind, and when we are discussing the uh, bill, we'll have to check, we'll have to analyze whether this is protected or not. So we have two things now. Dr. Manohar Naik's compound wall theory, and the Professor Manikyavel's information about the how the data from our body, human body, uh, is going to be used for further treatment. And you see, we do have at the moment we have a law which is known as Digital Information Security in Healthcare Act 2018. DISHA, Digital Information Security in Healthcare Act 2018. So that's a very specific piece of legislation on healthcare, providing healthcare. So whether this act, from what Professor Manikyavel has said, whether this act covers this aspect of how the genome sequencing generates data from our own body, and how it is used for treatment, whether this futuristic application is covered under the act is to be seen. So this is also a very valid and important point which we have to bear in mind. And with this, I thank Professor Manikavil. And now we will now cross the floor and go to the subject of law. And here, Dr. Dilshad, the Dean School of Law, Satyabama University, to say a few words on the subject. Dr. Dilshad? Can you hear me, Dr. Dilshad?
Yes, doctor. Yes, doctor. Good morning.
Yes, please. We would be happy to hear a few words from you on the subject.
Sure, sir. So, very good morning to one and all, respected Dr. Vincent SAILS, sir, Manohar Nayak, sir, and Dr. Alok Manikyaveru, sir, and other participants. It is my immense pleasure to be part of this discussion. Along with me, student representative Ms. Arya Abrenji has also joined meeting from Satyabama School of Law. And we are representing Satyabama Institute of Science and Technology in this discussion platform. Thank you very much for all the introduction, very genuinely and very gracefully that has been presented by the earlier speakers. And as we are all living in the digital world, I really believe that we all know like what exactly is happening with the privacy breach that is happening around us all the time. And of course, to tell something about me, my PhD thesis was on Hacking under Information Technology Act. During my research process, I met with ethical hackers, and I really understood like there is no system that has been built in the world like that cannot be breached. So even though my statement is very strong, but the data that has been collected for various purposes by many stakeholders, and of course there are a number of agencies, maybe from government, non-governmental organizations, or people from various sectors, they are collecting our information, and that has been utilized or misutilized rather, and subsequently our privacy has been breached intentionally, unintentionally, even if we don't want to give our data or share our data, we have been compelled, if not directly but indirectly. By knowing all these aspects, when there is a bill that has been actually placed in the form of like the data protection bill that need to provide for the establishment of an independent agencies, and we all know like there is a board that has been proposed under this bill that need to act very, very independently. What do we understand by the term independently, or a board that has been established to act independently? Whether the board is really able to function, or can we really imagine a situation wherein the board's powers have been given very distinctly to the board? The answer may be no. Along with this, there are multiple aspects that need to be discussed on this platform, and I really look forward for a very, very brainstorming kind of discussion in which we try to understand like whether the bill placed by the committee, or when the bill has been placed, whether that bill is a updated version of the thing, like the earlier bill was discarded, what betterment that had been happened, and what are the lacunas that need to be identified by all our committee members. And I really appreciate the initiation that has been taken by Dr. Cyril sir for this very, very amazing project we are into. And with the permission of the chair and with the permission of all the members, may I request the student representative from our institute to give a brief analogy about the draft bill. May I request Ms. Arya Abrenji to take over the session.
Oh yes, welcome Ms. Arya Abrenji. Dr. Dilshad, I think you have touched the most important point when you said it is only a matter of time before the breach is committed.
Yes.
Uh, in fact, I am happy to note that you have done your PhD on the subject, which is under discussion, and I'm very fortunate to have you on this group. Um, and as you said, it is only a matter of time uh, before a breach is committed and our information is stolen. So that only raises the question, uh, why our information should be entrusted to third party. It can be the state, or it can be an agency of the state, or it can be a private corporation, company, or it can be a private platform, any permutation and combination. Uh, why should we entrust our information to a third party? And it also leads to the question how we can protect our personal information by retaining control over it. So, thank you very much, Dr. Dilshad, for
Thank you,
throwing
Dr.
light
Siri,
on this
and
aspect.
student
Please,
representatives from School of
yes,
Satyabama Institute of
Miss
Science and Technology.
Arya, you can say a few words and uh, please introduce yourself.
Thank you, sir, and thank you, ma'am. Very good morning to one and all present here. My name is Arya Abranji, and I'm a final year student from School of Law, Satyabama Institute of Science and Technology. And might I add, I'm very privileged and honored to be a part of this online discussion. And my learned friend, a student representative from Satyabama, Aishwarya Kalyarasan, is also present in the meeting. So, the basis of our presentation is the decoding of the data protection bill. So we put a lot of hours into reading the contents of the bill. And my friend and I, under the guidance of our dean, Dr. Dilshad Shaikh, ma'am, we came across a lot of intricate issues and shortcomings in the particular bill. So we have prepared a brief presentation on what exactly the bill entails and what kind of issues it could possibly, what kind of issues and the impact it could possibly have on the data users. So with the permission of the organizers, we would like to share our presentation in order to share our insights.
Please go ahead.
Thank you, sir.
Yes?
Yes, sir. One second. Aishwarya, is it being shared?
I'm sharing. One minute.
So while we share this PPT, for us to understand this bill in the context of the current status of the country, we need to touch upon few aspects. So, for example, as per the UN, India is set to become the most. It has already surpassed China, and it has been crowned as the most populated country in the world. And the growing population of the country implies interactions with digital devices and internet, consequently resulting in humongous amount of generated digital data by users or users who are also known as the data principals. So this data is largely available on the internet, which can be effectively accessed and used by mega companies or organizations who are referred to as data fiduciaries here. So now by this presentation, we aim to discuss the very important aspects of this Digital Personal Data Protection Bill 2022. And we would also, at the end of the presentation, we would also like to touch upon the shortcomings and the issues of the particular bill. So, like I said, India being the most populated country in the world, there is a tremendous increase in the data users and data interchange. So, like I mentioned, the data fiduciaries, the mega companies and the organizations, they are generally very strong, and they have unfettered bargaining power as compared to the data principle. So, to an extent where they can influence the economy and the politics of the country, which is quite quintessential if we look at it from a bird eye perspective. So this bill is aims to provide proper framework of rights, duties, and recourses for the data principles, so that the problem of disproportionate power of fiduciaries or with the data principles are properly and adequately addressed. So, while we talk about the current legal framework that touches upon this particular subject of data protection, we don't have a very flawless or a very not very controversial kind of law in India. So the present the legal framework, primarily is the Information Technology Act of 2000 and the Information Technology Reasonable Security Practices and Procedure and Sensitive Personal Data or Information Rules 2011. But though we have these legislations, though we have these pieces of rules and lawful barriers, there have been certain issues. There have not. We find that the legislations do not function in the way they are supposed to function. They have failed to keep up with technological advancements, and they have also failed to take into account the growing population of the country. So there is a growing exigency to have a proper data protection law which was very mainly emphasized after the 2017 judgment by the Supreme Court, which I will touch upon later. So now, without further ado, we would like to proceed with the presentation by comparing the this particular data protection bill, with the type of framework that other countries, other unions follow in that particular country's context. So may I please invite my learned friend to carry forward the session.
Thank you, Ms. Arya.
Aishwarya?
Yes, sir.
Aishwarya, you are online?
Am I audible, sir?
Yes, please.
Yes, sir. Good morning to one and all present here. Myself, Aishwarya, from 5th final year, Satyabama Institute of Science and Technology. So, first of all, here I would like to share a few words about the data protection laws that have been available in other nations. So, when regard with a European Union model, a general data protection regulation mainly focuses on a comprehensive data protection law for processing of personal data. In this point, the General Data Protection Regulation is a legal framework which sets a certain guidelines for the collection and processing of personal information from an individual who live and outside of the European Union. In the European Union, the right to privacy is enshrined as a fundamental right that seeks to protect an individual's dignity and also the right over the data they generate. When it comes to US model, there is no comprehensive set of privacy rights or principles in the US, that like the EU's GDPR, which addresses the use, collection, and also the disclosure of data. Instead, in US model, there is a limited sector-specific regulations which approach towards the data protection, which is entirely different for the public and as well as private sectors. When it comes to the China model, new Chinese laws on private data privacy and also security issued over the last 12 months includes the Personal Information Protection Law, which came into effect in November 2021. And in this China model, it gives Chinese data principles a new rights as it seeks to prevent the misuse of the personal data. The security laws, the data securities laws, which came into force in September 2021, mainly requires the business data to be categorized by various levels of importance and put new restrictions on cross-border transfers. I would like Arya Abranchi to continue.
Thank you, Aishwarya. So, since we have discussed the kind of framework that other countries follow, let us now look at the data protection regime in India. So when we talk about the status of data protection in India, we have to most definitely have to discuss the judgment of Justice K.S. Puttaswamy versus Union of India, one of the landmark, one of the most pivotal judgments given by the Supreme Court of India in the Indian judiciary, in the history of Indian judiciary, might I add. So this particular judgment emphasized that every Indian have a constitutionally protected fundamental right to freedom, which is an intrinsic part of life and liberty under Article 21 of the Constitution of India. So, Article 21 is one of the most important fundamental rights that is promised to any person who live within the limits of the country. The Supreme Court in this particular case touched upon so many other subjects, so many other matters as well. But the right to privacy under Article 21 was greatly emphasized, and that is why I personally feel it is very important to emphasize on this particular judgment as well. Now, moving on further, we have the B.N. Sri Krishna Committee of 2017. So this is the committee which was appointed by the government. This committee consisted of a number of experts for data protection to discuss and deliberate on data protection under the chairmanship of Justice B.N. Sri Krishna in August 2017. So this particular committee submitted its report in 2018 along with a draft data protection bill. So in their draft data protection bill and in their report, the committee was of a greater opinion that there is a very important and significant need to strengthen the privacy law in India. So this was the foundation of the report as well as the the draft data protection bill. So this strengthening of privacy law is quite vague in nature. It could be read into as anything for a common man. So the report and the committee emphasized on certain important restrictions, such as processing and collection of data, the data protection authority, the right to be forgotten, one of the most important rights, which I will be again discussing in a later point of the presentation, and data localization as well. So this committee, it again, time and again, it emphasized on the need for to have a good workable privacy framework, legal framework in the country. Now, again, so when we look at the status in 2021, we have the Information Technology Intermediary Guidelines and Digital Media Ethics Code rules of 2021. So this was to mandate social media platforms to exercise greater diligence with respect to the content on their platforms. So this again is quite vague in nature. It is too wide in nature, so it could be read into as anything by a common man or by a data user or by a data fiduciary. So after all this, we have the draft data protection bill of 2022. So before we get into the discussion of the issues of the bill, let us now look at the key features. What are the salient features of the bill, which will be dealt by my learned friend Aishwarya.
Thank you, Ms. Arya Brenji. So I would like to put forward the key features of the Digital Personal Data Protection Bill. So there are various features. So the first main feature is the data principle. Here, data principle refers to the individual whose data is being collected. In this case of children who is under the age of 18 years, their parents or lawful guardians will be considered their data principle. And the next one is the main features will be the data fiduciary. Here, data fiduciary is an entity which may consist of an individual or a company or a firm or a state, etc. So, data fiduciary is an entity which decides the purpose as well as the means of the processing of an individual's personal data. Here, personal data can be any data by which an individual can be identified. Here, how it is processed is that the entire cycle of the operation that can be carried out in respect of a personal data. In case of high volume of personal data, here comes the significant data fiduciary, which comes to a role. At this point of situation, the central government will define who is the designated under this category based on the number of factors. Such entities will have to be appointed a data protection officer and an independent data auditor. The next main feature will be the rights of individuals. So what are the rights of individual that comes under this feature will be access to information, rights to consent, rights to erase, and rights to nominate. So the bill ensures that individuals be able to access basic informations in languages specified in the 8th schedule of the Indian Constitution. And also individuals need to give their consent before the data which is being processed, and every individual should know what items of personal data a data fiduciary want to collect and what is the main purpose of such collection and the further processing and all. And the main feature will be the data principles, which will have the rights to demand to erase and the correction of data that has been collected by the data fiduciary. And the data principal will also have the right to nominate a certain individual who will exercise these kind of rights in the event of their death or incapacity. And the next main feature will be the data protection board. Here the bill also proposes to set up a certain data protection board to ensure compliance with the bill. In case of any unsatisfactory response from the data fiduciary, the consumers can file a complaint to the data protection board. And then upcoming feature will be the financial penalties. In case of financial penalties, we can take up to two main aspects. One is for a data fiduciary and another is for data principal. When it comes to data fiduciary, the bill proposes to impose significant penalties on the businesses which undergoes data breaches or fail to notify users when breach happens. So in this particular situation, the penalties will be imposed ranging from rupees 50 crores to rupees 500 crores. And when it comes to the aspect under data principle, when a user submits false documents while signing up for an online services or fails frivolous grievance complaints, the users could be fined up to rupees 10,000. And when it comes to the exceptions, the government can exempt certain businesses from adhering to provisions of the bill on the basis of the number of users and the volume of personal data processed by the entity. This has been done keeping in mind startups of the country who had complained that the personal data protection bill 2019 was too compliance intensive. And the last feature will be the cross-border data transfer. Under this, the bill allows for the cross-border storage and also the transfer of data to certain notified countries and territories, which provides that they have a suitable data security landscape, and also the government can access data of Indians from there.
Yes, and now having touched upon the features of the bill, let us also look at the certain important or significant dimensions of the bill. So the first one is the applicability of this particular proposed draft. So there are two aspects to this particular applicability. Applicability. I'm sorry. So the bill will apply to processing of digital personal data within India, where such data is collected online or where it is collected offline and is digitized. So there are two important aspects to the applicability of this particular draft bill. So it also applies to processing of personal data outside of India if it is for offering of goods or services or profiling individuals in India. So this is the aspect of applicability of this under this particular bill. Now, second important dimension is the consent. It is the most debatable, it is the most controversial aspect of this bill, might I add. So consent, as we all know, it can be sought, it can be given. So personal data may be processed for a lawful purpose only when an individual, that is the data principal, has given the consent. So such consent can be obtained by issuing a notice to the data principal or the user, and such a notice must consist of all the details regarding the personal data which is to be collected, and the purpose for which it is required, and why it is being processed, and all such necessary information for such collection of data will be shared in the particular notice. Now, after giving consent, such a consent that was given can also be withdrawn by the data user or the data principal at any point. Now, this is consent in general, but there is a very hidden, a very concealed aspect called deemed consent. Deemed consent is where the consent is deemed to have been given by the data fiduciary. So this happens when the processing is necessary for performance of any function under a law, provision of any service or benefit by the state. Thirdly, medical emergency. Fourthly, for employment purposes. And fifthly, for any specified public interest purposes, such as be it national security, or be it fraud prevention, be it information security. So all these, if a particular processing of information is required for under any such ambit that the data fiduciary deems it necessary, then the consent would have been deemed to have been given. So this is the aspect of deemed consent, which is again a very controversial, which is again a very debatable aspect, which I will be further discussing in the under the topic of issues under the issues of the bill. So, while we talk about consent for individuals under the age of 18, consent will be provided by the legal guardian of the particular individual. Now, let us also take a look at the rights and duties of the data principal. So, an individual whose data is being processed, that is the data principal, will have the right to obtain information about the processing. Why or what kind of process is being is happening, or why is it being obtained, is all these why, what, and other questions can be can be considered as a right of the data principal. Secondly, the data principal might seek correction or erasure of personal data. And thirdly, the data principal might nominate another person to exercise rights in the event of death or incapacity. And finally, we have the grievance redressal. So while we have rights, we also have accompanied duties as well. So data principals have certain duties. For example, they must not register a false or frivolous complaint under the pretext of there has been an infringement of their personal data. So whatever complaint that they have, or any grievance that they might have, it must be genuine and it must not be malified in nature. And secondly, they should not furnish any false particulars, or they should not suppress any information or impersonate another person in specified cases. So if any data principal or any data user is found to be in violation of these duties, will be fined accordingly with a penalty of rupees 10,000. So this has been specified under the proposed draft bill. Now, we have taken a look at the rights and duties of the data principals. Now let us ponder over the ambit of obligations of the data fiduciary, which is very, very essential. So the entity determining the purpose and the means of processing, they are called as the data fiduciary. They have very important duties that they need to follow in order to ensure that this processing of data, personal data, the way in which it is being asked, the way it is being processed, the way it is the status is after the process is over, everything depends on the data fiduciary. So they have few important duties. Firstly, they need to make reasonable efforts to ensure the accuracy and completeness of the data. So they cannot be quite negligent, or they cannot take it very lightly. The data fiduciary, they have a very important duty to take the data towards higher security. And secondly, they have to build reasonable security safeguards to prevent a data breach and inform the Data Protection Board of India and affected persons in the event of any breach that has, if it has happened. So this again is quite elementary, because it is very obviously the duty of the data fiduciary to make sure that the data that is being given to them for legal reasons, for lawful purposes, is being protected and safeguarded properly by the data fiduciaries, because we cannot afford a data breach, and that will not look good considering the massive population of India. We cannot, that is a problem that we as a country cannot afford to have. So that is one of the most important duties that the data fiduciary need to ensure that it is proper and it is functioning smoothly. And thirdly, it needs to cease to retain any personal data as soon as the purpose has been met, and retention is not necessary for legal or business purposes. So this again, it is the duty of the fiduciary, because just because a data principal agrees to share a personal data does not mean that it has been agreed to have been shared indefinitely. So there is an expiry time, and the data fiduciary should be mindful of the data that it possesses, and there should be a cessation of the retention of that particular personal data. And finally, there is a very important aspect to this particular bill, which is the transfer of personal data outside India. So the central government will notify countries where a data fiduciary may transfer personal data, and these transfers that has been authorized or that has been given permission will be subjected to particular terms and conditions. So nextly, we have a few important pivotal principles of this bill, which will be discussed by my friend.
So I would like to emphasize on the principles of the 2022 bill. So firstly, the usage of
1 minute for, sorry to disturb you.
Yes.
We have other speakers online, so I would suggest that you try to complete your presentation within the next few minutes.
Sure.
Sure.
Thank you.
Thank you. So, firstly, the usage of personal data by several organizations must be done in a manner that is lawful and fair to the individuals and concerned and transparent to the individuals. Secondly, personal data must be only used for the purpose for which it was collected. So, it should basically focus on data minimization. The collection of personal information should be limited to what it is directly relevant and necessary to accomplish the specified purpose. And it also have to emphasize on the data accuracy when it comes to the collection of data, which means it is an error-free records that can be used as a reliable source of information. And the next principle talks of how the personal data is collected cannot be stored perpetually by default, and the storage should be limited to a fixed duration. And also there should be a reasonable safeguards to ensure that there is no unauthorized collection or processing of personal data. And the main principle states that the person who decides the purpose and the means of the processing of personal data should be accountable for such processing. Now, the key issues and aspects will be dealt by my learned friend. Thank you.
Thank you. And as I'm aware of the time constraints, I would like to keep the discussion about the issues very short. So let me just give a brief outline about the possible issues that come under the implementation of this particular bill. So firstly, we have the adverse implications for privacy. Privacy is the main concern of the bill. We don't know what kind of infringement could possibly happen when a personal data has been shared by the data principal. So that is a very important, very, very serious issue that needs to be looked upon. And secondly, we have the unchecked data processing. So what kind of data is being processed for what, and all the necessary ambits of the data processing is not being discussed in clear and in understandable manner. So that is again an issue. And thirdly, we have the prevention of dissemination of false statements of fact. So this particular phrase has been mentioned in the bill as the ground for of a public interest purposes in order to obtain deemed consent. So this again raises the question of why there is even a need for such a ground. So that is again an issue. And nextly, we have the implications of exemption from data fiduciary obligation. So that again, data collected by police for investigation and prosecution of one offense may be utilized for other purposes. So where does the restriction stand? Where does the limitation stand? Is again very ambiguous. We don't know the limits, the boundaries of such data sharing. And the independence of Data Protection Board of India. This again is a very, very serious issue, because be it the terms of appointment, be it the composition of the particular board, and everything pertaining to the board is being decided by the central government. So that again raises a question of how, to what extent the Data Protection Board of India can function independently without any influences of other functionaries or other instrumentalities of the government. So that is again an issue. And next we have the right to data portability and the right to be forgotten, two important rights that a data principal possesses. So the first one, the right to data portability, allows the data principals to obtain and transfer their data from data fiduciary for their own use in a structured, in a commonly used and a machine readable format. And nextly we have the right to be forgotten, which refers to the right of the individuals, that is the data principals, to limit the disclosure of personal data on the internet. But the proposed draft bill is silent on these aspects, because there is no express barrier, or there is no express restriction on these particular rights. We don't know from where the right to be forgotten starts. We don't know from where the right to data portability can be derived. So that is again quite ambiguous in this aspect. And we have verifiable parental consent. So this concerns the individuals under the age of 18. So when the bill requires all data fiduciaries to obtain verifiable consent from legal guardian before processing the personal data of the child. But beyond verification by mere declaration, there is no other form of verifiable mechanism in order to obtain personal data. So mere declaration is not effective if we look at it from a legal perspective. The declaration, any person, any individual can give a declaration. So we don't know what is the intention behind such a declaration. We don't know how effective the declaration is in its simple sense. So that is a very intricate issue that needs to be looked into. And next we have the definition of child from other jurisdictions. So the very definition of child under this bill means a person below the age of 18. But when we'll take a look at the frameworks in USA and the UK, we see that persons above the age of 13 can give consent for the processing of personal data. So we find that there is a lack of balance. There is a lack of international conformity on part of this particular proposed draft bill. And next we have the definition of harm. This again is a very important issue. I will wrap up in a couple of minutes. I apologize for taking such a long time. So definition of harm. Harm in relation to the data principle under this bill is being specified as any bodily harm, be it distortion or theft theft of identity, harassment, or prevention of lawful gain or causation of significant loss. But this is very narrow in nature. While we compare this particular proposed draft to the 2019 draft, we find that harm has a very wider ambit. It includes mental injury, it includes loss of reputation or humiliation, it includes discriminatory treatment, it includes blackmail, extortion, any observation or surveillance or not reasonably expected by the data principle, restriction of speech, movement, or any other action arising out of fear of being observed or surveilled. So there is so much more to the definition of harm under the 2019 bill and opposed to the 2022 bill. So which is again a very concerning issue. But the Joint Parliamentary Committee recommended adding psychological manipulation that impairs the autonomy of the individual to the list. But however, it cannot be found in the 2022 draft bill. And finally, we have the last issue, which is the lack of clarity on what constitutes as a significant loss. Now, harm includes prevention of lawful gain or causation of significant loss. But it is very unclear about what exactly constitutes as a significant loss. What might appear to be significant loss to me might not appear to be significant loss to another person, to another data principle. So there is no there is no clarity, there is no guidance on determining what is significant loss and what is not a significant loss. So upon decoding the contents of the 2022 bill, we found these issues under these these shortcomings under the bill, which can have a very profound impact on the data protection framework in India. So, on this note, I would like to conclude our presentation, and we would like to thank the organizers for giving us this wonderful opportunity where we could share our insights. Thank you again. Thank you.
Thank you very much, uh, Arya and Aishwarya.
Thank you, sir.
Thank
You
you.
have, you have to be commended for the work you have put in, and since you have started the analysis from the population point of view, it has actually triggered something in my mind. Of course, we are going to, or maybe we must have overcome the population of China, but the majority of the population is not, how to put it, device literate, or they are not used to. The majority of the population is living in rural India. So in rural, unlike the urban centers, we cannot decide or we cannot think only from the population which is living in our metropolitan cities and urban areas. We have to think of the people, the majority of the population which is living in the rural area, who do not have access to most of the facilities which their counterparts in the urban and metropolitan cities enjoy. So even if they want to do a small bit of banking, they may have to travel to several kilometers to reach a bank. And the digital world is not a very familiar world for the majority of the population in India, and their access to the digital world is a big question mark. But without their knowledge, without their consent, or without their awareness, without they being aware, their personal information is already in the digital world. So the we have to think in terms of the federal structure which is contemplated under our constitution. Uh, so the question which I would like to pose is that, and for everyone to think about it, is that uh, I am living in a small town. I am living in a small village, and would it be convenient, prudent, and practical for me to entrust my protection to a distant authority in Delhi or in a distant city? And would it be wise for me to allow somebody else in a faraway place to protect my data? Will it not be better if I am able to protect my personal data from my house or from my village, instead of knocking the doors of a distant authority? So the board which is contemplated under the proposed bill, first of all, is not very efficient. It lacks on several aspects, like jurisdiction, the capacity of the persons in the board, and other things. So this is something which has to be explored, and I would be very happy if we can, uh, think on the lines of a federal structure, which means the devolution of the responsibility should be at my doorstep. Uh, I should be able to do things from my computer or from my house or from the nearest officer of the state. Like the nearest officer of the state in most of the villages is the village administrative officer. So every time we have to go and we have to ask somebody in the city, somebody in the Delhi or in some other metropolitan city is not a very practical way of protecting my personal data. So we have to think in terms of the federal structure and explore the possibility of devolution of the protection of data uh, at the lowest level instead of the centralized highest level. So that is something which we have to think about it. Uh, and I thank both of you for a very good analysis of the bill and highlighting uh, several uh, points or several important aspects which have been ignored in the bill. And a reading of the bill creates more doubts than offering solutions. In short, it is not a very comprehensive bill. That is what I also felt when I went through the bill. But anyway, thank you very much for the tremendous work that you have put in. Uh, we all appreciate the hard work that you have done. Thank you very much. Now, there is somebody else also who, a student of VIT called Pooja Padmanabhan. Are you online?
Yes, sir.
So please come forward and you can present your analysis. And I would only request you that since we are fast approaching lunch time, I would only request you to make it short and sweet. Please go ahead.
Yes, sir. So am I audible?
Yes, I think a little more volume would be nice.
Yes, sir. So having seen the features and the important aspects of the bill, I'll more focus on the issues. I'll more go in detail on the issues aspect. So to begin with, the first thing that I noticed was the board that was set up and the independence of the board, which was uh, correctly mentioned by ma'am and the previous presenters. And the another aspect of this bill, which is vague and wide, and I got a doubt here, was that the clause 18 of the bill of 2022, because it carries forward a wide and a vague exemption, and this was also prevalent in the previous bill. So the Data Protection Bill 2021's clause 35 is very much replicative in nature of the clause 18 of the bill. In particular, if I should speak, it is on the subsection 2A of the clause 18, as it deals with the instrumentality of the state from the application of the bill, and it also, this is vested upon the interest of the sovereignty and integrity of India and security of the state. So this particular aspect, because it notifies the government the instrumentalities and immunities from the application of the law, which could result in immense violation of citizen privacy. It is giving exemptions to the government, it's giving, which would actually lead to state surveillance over the data of the citizens. And any exemption sought by the government agencies should be granted only if they fulfill the standards of legality, necessity, and proportionality. And it is essential that the government collection of data and the processing of such data is regulated to ensure that misuse is also not happening. And the privacy aspect, which is very crucial in a protection bill, is not completely taken care of in the bill that we have been discussing so far. And talking about the deletion of data, which has also been discussed prior, the retention of data. So the clause 9 of the bill does provide for certain circumstances where the erasure of personal data, such as like retention, is no longer necessary for business purposes, stated in the bill. So it leaves actually a broad ambiguity when there is a whether there is a legal obligation on the part of the fiduciary to delete the data or not. And reading it with the clause 13, which requires data principals to take active steps to ensure that the data is deleted by the data fiduciaries. And also the clause 18, the vague wording of the clause 18 essentially gives the government a carte blanche to exempt itself from any other data fiduciary from the application of the bill. So in this way, though the bill also speaks about the deletion of data, erasure of data, but it also talks about the retention, which and the steps needed to be taken by the data principal for erasure of data. So such vague ambiguities also brings a doubt whether is the data mandatorily supposed to be deleted or not, was something I could find as I read through the bill. And the central government's formulation of the board actually reduces the independence of the data protection board, and it may also house the jurisdiction of civil courts because the chief executive of the DPB will be appointed by the union government under clauses 19 part 2 and 19 section 3 subsection 3. And moving forward is the gaps. There are certain gaps in this piece of bill, which, for example, the word "as may be prescribed" has been mentioned for about 18 times in the very bill. And for example, as may be determined, may by notification, may determine, has also been mentioned for 20 times in the 24-page bill. So this has actually allowed the union government to get away with the vague and unchecked powers that data protection bill has provided it to frame rules at a later stage without proper legislative guidance. And this particularly concerning the provisions of clause 8 of the bill, which allows the union government to prescribe fair and reasonable purposes for which data principal will be deemed to have given consent to the processing of our personal data. And another aspect was about the financial penalties. We've discussed already about the financial penalties, but one thing I could note here was that though we have financial penalties levied upon the data fiduciary, but in case of a data breach, does the victim under the proposed act seek any monetary compensation? There are no clear guidelines stating that the victim can seek a monetary compensation with the aid of the act. Further, the duties of data principal. We also saw that there are duties on the data principal and also financial penalty being imposed on the data principal according to the clause 16 of the bill, which states that the data principal shall, under no circumstances, including while applying for any document, service, unique identifier, proof of identity, or proof of address, furnish any false particulars or suppose any materials material information or impersonate another person. So, in point of this matter, say the person is entering a store and is purchasing a commodity and is asked to, or say person is entering a store and in a circumstance where a person is asked to provide their personal data like name or phone number, and the individual is not completely in a position where they are willing to provide this such data, or they, to avoid confrontation, they may end up giving false data. And under such circumstances, they will again be uh, having to face the financial penalty. And such a clause of duty over a data principal is pretty unheard of because it has not been there in the previous legislations and the legislation in any other data privacy law for that matter. And another thing that I noticed was the aspect of child and the definition and the aspect of how the law, other laws, GDPR, uh, is defining child as any person below 13, which has also been mentioned of. So I would like to summarize with this much, as these are the criticisms or the issues I felt I could notice, and I felt were vague in nature in the given bill that we are discussing. Thank you, sir, for the opportunity.
Thank you, Pooja. Uh, Actually, we have you have highlighted some ambiguities in the bill, and you have raised the issue of how far the board will be independent. So that is why I have my own reservations about the board and how effective it would be, because we have in India, we have a culture of creating boards and commissions, uh, but in the long run, they become very redundant and ineffective. Like, for example, you see the under the Right to Information Act, we have Chief Information Commissioner and other commissioners and all that. It has become so cumbersome for us now to exercise and enjoy this right to information, because they are not very effective. They are sitting in Delhi, and they are not even having the time to hear you present your matter. Even before hearing you, there are instances, several instances, where they have come to a decision. And that is why, that is one particular instance of the commissions or boards uh, giving exercising jurisdiction or authority to settle disputes. Similarly, you have the Consumer Protection Act, the National Consumer Commission sitting in Delhi, the state commission sitting in the capital of the state, and the working of these acts and commissions have highlighted that their access is very, very difficult. Uh, Access to justice is a basic fundamental right under Article 21, but if you are in a remote place of your state, very difficult for you to go and access these authorities. So you have highlighted some important features regarding the ambiguity and the independence of the board, and I am sure we will concentrate on this aspect in the next stage of our discussion, uh, and prepare accordingly. Thank you very much, Pooja. And now we have a faculty member, Dr. Prabha. Are you there? Dr. Prabha, are you there? All right. I think we are not able to connect to her. So the time is now 12:45. We have already uh, discussed. Prabha, you are there?
Yes, sir, I'm here.
Very good. She is a assistant professor from the School of Law, Sri Manakala Vinayagar School of Law. Prabha, you have a few minutes to give your input.
Okay, sir. Okay, sir. Good afternoon, one and all present here. I'm very much privileged to be a part of this discussion. I'm really thankful to Cyril sir, and as the due to the limitation of time, I would like to ask only one thing. I would like to share my opinion regarding the ADR mechanism. Is it audible? Hello?
Yes, it is. Yes, it is.
Yes, sir. The ADR mechanism has been adopted by this bill. A draft proposed bill is very nice to hear, but I need some clarification regarding that. Whether the party can choose by themselves to, they can opt for ADR mechanism on their own, or they have to approach the board. And as per the bill, it is mentioned that the board, in certain cases, may opt for, suggest for ADR mechanism for redressal. But whether the party themselves can go for alternative dispute resolution mechanism, and that needs I need some clarification regarding that. Hello.
Yeah, can you hear me? Yes.
Yes, sir.
See, the provision that is in the proposed bill, in the proposed bill, it is the board. If the board is of the opinion that any complaint may appropriately be resolved by a mediation or other alternative dispute resolution, the board can direct the concerned parties to attempt such resolution. So it is not
Okay.
in the hands of the individual, the principle, data principle, which is referred. Actually, the individual is not having the liberty that is the whole uh, scheme of the bill itself reveals this aspect. The individual has no major role to play,
Okay, that is
either
clear, sir.
either
Uh,
in protecting uh, his or her data, personal data,
hmm.
uh, or in case of breach, to seek for redressal of her grievances.
My doubt is regarding the board will go for, I mean, board as an option, it can go for ADR.
Yes, yes.
But my
It
question
is
is,
not
what
for the
is the price?
individual. It is not for the
Okay, to
individual to
decide.
decide. If the
Okay,
board comes to the opinion, that opinion
okay,
should be formed by the board, and if the
uh,
board forms such an opinion, then it can direct the parties
to
to
approach the
make an
ADR.
attempt to resolve their dispute through mediation by a body. Most important
Hmm.
thing is by a body or group of
Hmm.
persons designated by the board.
Okay,
First thing, the
I,
board
uh,
itself will dictate or designate who shall be the persons who will be attempting to resolve the dispute.
okay. One
So,
thing I would like to make
uh,
clear is, is there any criteria to determine which case can be referred to the ADR? Is there any criteria like that based on the pecuniary limit or monetary value or
uh,
territorial
you see
jurisdiction?
that,
On
yes,
what basis the board decides that the ADR should be referred? That is my doubt.
you see, uh, this jurisdiction is determined by the processing of the data,
Hmm.
and the board will have jurisdiction for all matters within India.
Hmm.
So, unlike your normal civil law, which provides for determination of jurisdiction based on where the defendant resides or where the cause of action arose, unlike that, we don't have uh, that kind of an approach in this bill. The that is the board. The board will have jurisdiction uh, for matters or breaches uh, arising in the use or misuse of the personal data within India, or where the if where the mostly it is within, that is in India. The board means it is the board established by the central government for the purposes of this act and for the purpose of uh, taking up complaints for breach of data within India.
Okay, sir.
The fiduciary, that is the fiduciary who is entrusted with protecting your data, must be in India. That is the only way, that is a simple way of putting it. All right.
Okay,
Thank
sir.
you.
Okay,
Thank
sir.
you.
Thank
Thank
you.
you. Thank you. And quickly, we have another person, Ashida Hidros. Uh, are you there, ma'am?
Yes, sir.
Would you like to add something more?
Yeah.
Please.
Already my name is Hashita Hydros. I'm doing PhD from Central University of Kerala, and I think the technical aspects of the security, all those things are already almost covered by my research supervisor, Dr. Manohar Naikas. And while listening this session, this was very interesting. Same time, I feel it's a controversial topic because as per the points explained by Miss Arya and Aishwarya, what I understood that this particular bill, we can see this data protection bill as a double-edged sword, right? Because what I feel is, at the same time, on one hand, it provides some kind of important protections for personal data of user or people, and it enables people to access government services by protecting their personal information. And on the other side, it also raises some concerns regarding privacy. That is the major crucial thing everyone discussed all over in this session, because the government has the supreme power over this personal data of people. So the bill should, my point is, or as a user, common user, my doubt is the bill should also address the transparency of this point also. How much level all this personal data can be utilized, can be used by the government authorities, all those things. So there should be, if any transparency is there, then if I am wrong, anyone can interrupt and make me clear, because these things, these legal and government law, regarding law information, I'm not that much. I don't have that much knowledge, and this is what the common doubt I have. How the transparency is ensuring by implementing this data protection bill. And but we are in case of technical things, for example, uh, in India, Aadhaar card, we know that in starting of the session itself, Sir Vincent sir also mentioned this point, the Aadhaar card. It's a controversial topic. Many debates are going on based on this, whether our data, or every data, including our biometric information, everything is encapsulated in Aadhaar card. So there is a purpose of Aadhaar card. We all know that, because the citizen can easily access every government services by using the single Aadhaar card. So some users services are provided, but in a technical aspect, as per my knowledge, I think the Aadhaar card informations are stored in a centralized database. That is right. I think because we are the system completely depends on that centralized data. So there is a chance of data breach, because complete system completely depends on that centralized database only. So the security of that centralized data should be very important. That should be addressed. How the security is provided. Maybe some cryptography encryption techniques, or some other authentication techniques may be incorporating by the government. But uh, why this centralized mechanism is the prior option, or why or can be shifted to some kind of distributed storage of this data set, because if we are distributing every data in a different servers, if even one server is getting low or getting down, that data may be corrupted or manipulated. The data is available in another server. So that there is a we should utilize the um, positivity, or we should utilize the distributed mechanism strategy also, apart from centralized security system, centralized database storage. So as a brief, I'm not going in detail regarding all over the security technical aspects, but the briefly we can say the data it have to secure in storage and also in transit. In storage means while it is storing in some repository, and also second aspect is in transit. The data should be secured in transit. Transit means while transferring. For example, if I am sending one data, my here itself I am speaking. Actually, my voice is a data, and you are receiving my data. So while transferring the data, the security also should be addressed. So that algorithm should is algorithm considering the security in transit mode also. And another third point is the data in end user device protection. For example, our smartphone. So in our smartphone, every daily routines, every services, we are depending on applications, some kind of applications. So how can we protect even our single smartphone device? All those things are very important, and as a user should be aware of these things, because I'm not guaranteeing that, as a research scholar in this field I can say there is no a permanent solution. If we are in a digital world, somehow our data is compromised, because if we are taking a photo in our phone camera itself, that photo is a permanent data. If we are deleting, even if we are deleting or removing it from our device internal storage, then what we are thinking, yeah, everything is removed, but it is not like that. If you that permanent photo is itself is a permanent data, because there is no any removal. Even if we are removing the data is an asset, we can somehow recover that data only by breaking the physically, by only by destroying the device physically, we can ensure, yeah, our data is removed completely, erased completely. That's the only promise I can say, because in digital world, uh, what we can do is we can somehow minimize the impact of this data breach or cyber attacks by, we should be aware of some cyber attacks, for example phishing links, as mentioned by my supervisor Dr. Manohar Naik sir. Phishing link, if you are clicking some kind of button, some kind of malicious link in an SMS or in our email, we should be very careful, because as a citizen, we should have a digital literacy, as well as we should have a security literacy also. Digital literacy means we can use, we know how to use a smartphone device. Even in 60s, people can also use. Everyone can, everyone know how to use a smartphone device. But same time, everyone should also know how to secure our smartphone device, because no, not only the usage is important, we should also able to protect our device by awareing about the malicious link. That's one point. And another thing is, we should download every applications. I'm speaking about the smartphone end user device protection. Actually, some brief precautions only. Okay, we should download any applications from trusted sources only. For example, Google Play services only. If we are getting any link, if we are prompting to, yeah, you can download this from this by clicking this link, don't do that, because only navigate to the Google Play Store, and only after verifying whether the source is trusted and authenticated, then we can download it. Even though Google Play Protect provides some kind of services. For example, while downloading applications, it will automatically verify. But that single mechanism is not enough. We can use some kind of anti-malware applications to scan our device. Every installed app can be scanned, and if any suspicious acts we are encountering, we should uninstall it, and we should check what are the permissions we have granted to those applications. Permissions means, for example, camera is a kind of permission, and contact permission. For example, uh, calculator. Suppose we have a calculator application, and some just a simple example. And for installing that application, if it is asking for some kind of contact, it requires to access your internal storage, or it requires your access your camera. That is not needed, because for performing a simple calculation, these kind of camera permission or internet permission, these are not necessary, not compulsory, not needed actually. So if any application, if any malicious, if any suspicious applications while installing is asking you for granting some kind of unwanted permission, unwanted means some sensitive permissions, then you should be aware. Don't allow that permissions to be granted. So permission mechanism is another kind of security mechanism provided by smartphone, especially Android. And another thing is, in a in a personal PC desktop system, there should be a firewall protection. Firewall protection will filter every unwanted network traffic, and uh, if any trackers, if we are surfing through internet, maybe some kind of trackers can track, steal our cookies, like our Google history, our saved passwords, all those things. So by providing anti-malware, antivirus, and firewalls, and also uh, creating strong passwords. These are the simple techniques. Uh, in every case, we usually have the habit like using a same password for every apps. For example, for my Amazon, for Netflix, for every app. In order to remember easily, I'm putting my name Hashida123. But that is not a strong password. So if you are creating a password, we should be created a in strong format. For example, the password should be contain combination of letters, numbers, special characters, and some kind of uh, count of digits like that. So strong password is it. And another important thing to ensure security is multi-factor authentication. In every phone we have, in Gmail itself, if one factor fails, we can link our mobile number with Gmail. If anyone know our Gmail password, while they are trying to uh, log in our Gmail with the hacked password, then if that device is a new device, the Gmail security system will detect, yeah, someone is trying to log in this Gmail account from a different device. Usually, this person uses some other device. For example, I'm using Windows, and in some attack scenario, maybe hacking your password and trying to log in your Gmail account. At that time, an SMS OTP verification will come to your linked mobile number or other kind of two-factor authentication, biometric authentication. All those things are basic security precautions that we should practice. We should practice. So, and also, another thing is that we should update up to date our system. If you are using same Windows previous version, that is not a good idea because we should update every time. Every software we are using, we should update regularly, frequently, because in each update, every bugs or every errors will be patched up in latest version. For example, in Windows 7, some kind of bugs may be there. If we are using Windows 7 this time, maybe attackers can easily sneak through your system. They can easily get your personal information, credit card details, passwords, everything. So we should update regularly every software that we are using. So I just summarized the small tips or basic. I think most of them may be aware of these precautionary measures. Even though user, even though startingly I mentioned that there is not a fixed permanent solution. So by combining this bill, data protection bill, I can say in order to build a secure digital ecosystem, you can say, in order to build a secure digital ecosystem, both the security research practitioners from technical aspects, as well as the legal authorities from like laws and government authorities, should work in parallel, combined in integrated format. Then only we can survive in this digital world. That's what I would like to add to this session. If anything you want to know, you can wrong in any point.
Thank you, Ms. Hashida Hydros, for highlighting the security aspects of the data protection. So we had a very stimulating session today in the group. I think if you will permit me, we can conclude the session. And most of the speakers here have contributed very good ideas, stimulating ideas, and it lays the foundation for further work, for further research. Of course, I am sorry, there are a couple of other students also who are participating, but over the time factor being a constraint, I am unable to take it forward in continuing the session right now. But the speakers have contributed quite stimulating ideas, and it is a good way to start the discussion and keep it going further. And I have only a couple of things to say before we close. One, the institute, the Arvind Institute for Legal Studies, will be happy to receive your written articles on the subject, because eventually we intend to publish a report on the data protection bill, and those who are interested, the participants here, those who are interested can contribute their written articles for publication by the institute. Of course, your articles will be reviewed by a group of peers in the subject, and then if it is approved by the uh, board of peers who review your article, it will be taken up for publication. Publication can be both, it will be on the website of the institute as well as in the printed format. That is one thing. Second thing is, since the subject is of importance to a lot of people, we will have, I will of course consult with the teaching faculty here, who are attending this program. We will consult with the teaching faculty, and we will, subject to the arrangement of examinations and other things, we will organize a national seminar or a national conference on the subject. I am thinking of the month of April, but of course, please feel free when it would be convenient for uh, the teaching faculties as well as for the students, which would be the appropriate time to have the national seminar or a national conference. And you please let me know, and accordingly we will arrange. And I am open to the institute. The members in the institute are open to have a joint conference or a joint seminar. So the teaching faculty can think about it. But in any event, please let me know the convenient and appropriate time to organize this follow-up. As a follow-up to this group discussion, we will have a wider consultation in the form of a conference or a seminar. So only thing is, you'll have to let me know which would be the appropriate and convenient time for the students as well as for the teaching faculty to participate. And because it might be in the next will be follow-up will be in a in-person physical conference or seminar, so you may have to travel, so you let me know the convenient time for having this program. Then finally, I thank all the participants for accepting our invitation and participating in the discussion, contributing your time and effort. I could see all of you have put in quite a lot of work in your presentation. My special thanks to Dr. Manohar Naik, to Professor Manikawel, to Dr. Dilshad, and the Assistant Professor Prabha, and the participants, the students who have participated for the effort and time. Thank you one and all. And we have a feedback form. We are posting a feedback form. It has already been posted, so you can give your feedback in that form, and you can also mention the probable date when we can organize a seminar or a conference. Thank you very much. I'm very happy to have met you, particularly Dr. Manohar Naik.
Thank you, sir. Thank you so much.
I hope to meet you in person sometime.
Sure, sir. Sure, sir. Definitely, sir.
So, thank you.
Thank you, sir.
And
Thanks a
have
lot.
a good weekend.
Thank you, sir. Thank you.
Thank you. Thank you.
Thank you.
All right. Okay.
Thank you, sir.
Thank you.